The Partnership Act 1932 Nature and Characteristics of Partnership. When one person wants to start a business, he may form a sole proprietorship when the business is small. The amount of money that the sole proprietor can contribute to the business alone is not very high. Besides this, the sole proprietor has to take wise decision in running the business. He is unable to do so, the business will not be very successful and will not grow. A sole proprietor might be an expert at marketing or might be technically strong, but it is not likely that he will be strong in all the fields that are important for making wise and successful business decisions. The joint efforts of all members results in successful accomplishment of task, and that task or job can be easily afforded. Division of work leads to increase in efficiency at work among different partners. Initially, partnership was governed by provision contained in section 239 to 266 of chapter 11 of Indian Contract Act 1872. These sections were repealed in 1930 and new act, the Indian Partnership Act 1932, was passed. Short title: Extent and Commencement. First, this act may be called the Indian Partnership Act 1932. It extends to the whole of India except the state of Jammu and Kashmir. It comes into force on 1st day of October 1932 except section 69, which shall come into force on the 1st day of October 1933. The word partner is associated with the French term partenaire, which means joint heir or one that shares or has a part with another. The term can also be broken down to two part, which means to divide or to share. Nature of partnership. Partnership is a form of business organization where two or more persons join together for jointly carrying on some business. Short title: Extent and Commencement. This act may be called the Indian Partnership Act 1932. It extends to the whole of India except the state of Jammu and Kashmir. It came into force on the 1st day of October 1932 except section 69, which came into force on the 1st day of October 1933. The word partner is associated with French term partenaire, which means joint heir or one that share or has to a part with another. The term can also be broken down to two part, which means to divide or to share. Nature of partnership. Partnership is a form of business organization where two or more persons join together for jointly carrying on some business. It is an improvement over the sole trade business where one single individual with his own resources, skills and efforts carrying on his own business. Due to the limitations of resources of only a single person being involved in a sole trade business, a larger business requiring more investment and resources cannot be thought of in such a form of business organization. In partnership, on the other hand, a number of persons could pool their resources and efforts and could start a much larger business that could be afforded by any one of these partners individually. In case of loss, the burden gets divided among various partners in a partnership. Definition of partnership: partners, firm and firm name. Section 4 of the Indian Partnership Act 1932 defines partnership as the relation between persons who have agreed to share a profit of a business carried on by all or any of them acting for all. Persons who have entered into partnership with one another are called partners. Persons cannot be entered into partnership contract such as alien enemy, minor, person of unsound mind, corporation. The members of a Hindu undivided family carrying on family business. A Brahmins Buddhist husband and wife carrying on business as such. Example: A is goldsmith. He agrees with B to buy and provide gold to B for making ornaments. They plan to sell the ornaments and they plan to share the profit. Here A and B are partners. A and B are carpenters. They decide to work together, but they have an agreement under which A will keep all the profit and pay B a predetermined salary. Here A and B are not partners. Persons who have entered into partnership with one another are called individually partners and collectively a firm. The name under which their business is carried on is called the firm name. The firm name is only a short way of expressing the names of all the partners. A firm name shall not contain crown, emperor, empire, imperial, king, queen, royal, or words expressing or implying the sanction, approval or patronage of the government. The state government may, however, signify its consent to the use of such words by a firm as a part of its name by order in writing. Section 58, subsection 3 highlights on registration of partnership. The Partnership Act does not provide for the compulsory registration of firms. It has left option of the firm to get registered, but indirectly by creating certain disabilities from which an unregistered firm suffers, it has made the registration compulsory. Section 69 deals with such disabilities. Registration offers protection to outsider dealing with firms. Procedure of registration is mentioned in section 58 and 59. Section 57 empowers a state government to appoint registrar of firms. The Partnership Act defines the areas within which they shall exercise their power and perform their duties. The application for registration of firm shall be accomplished by prescribed fee. It shall state the name of the firm, the place of the business, the name of other places where the carriage of business, the date when each partner join the firm. The name in full and permanent address of the partners, the duration of the firm. The statement must be signed by all partners or by their agent specially authorized in this behalf. Students, we will highlight on effects of non-registration. Under section 69, suit between partner and firm. A person suing as a partner of an unregistered firm cannot sue the firm or any partner of the firm to enforce a right arising from the contract or confirmed by Partnership Act. He can do if the firm is registered and the person suing is or has been shown in the register of firm as a partner in the firm according to section 69 subsection 1. Suits between partners and third party. An unregistered firm cannot sue third party to enforce a right arising from contract until the firm is registered. The names of the person suing appears as partner in the registered firm section 69 subsection 2. A complaint filed by unregistered firm is contravention of section 69 subsection 1 and subsection 2 is treated as void complaint. This view finds support from the decision of Supreme Court in the case Lokaran Sethia versus Ivan in John in Shriram Finance Corporation versus Yasin Khan. A suit by the partner was hit by provision of section 69 subsection 2. As on the date when the suit was filed, two of a partner shown as a partners as per relevant entries in the register of the firms, where in fact partners, one new partner had came in and two minor partners had been admitted to the benefit of partnership for regarding which no notice was given to the registrar of firm. Thus, the person suing, namely the current partners in the register of firms, as such the suit was not maintainable in view of the provision of section 69 subsection 2. Students, we will highlight on claim of set off. An unregistered firm or any partner thereof cannot claim a set off in a proceeding instituted against a firm by a third party to enforce a right arising from contract. Until the registration of the firm is effected, section 69 subsection 4 subclause B of set off does not exceed rupees 100 in value according to section 69 subsection 4 subclause B. Partnership agreement. Whenever you think of starting a partnership business, there must be an agreement between all the partners. This agreement contains the amount of initial capital contributed by each partner, profit or loss sharing ratio for each partner, salary or commission payable to the partners if any, duration of business if any, name and address of the partners and the firm, duties and power of each partner, nature and place of business, and any other terms and conditions to run the business. The partnership deed is usually not very hard to prepare through a trusted local lawyer. Partnership deed. It describes how the partnership will be run and the rights and duties of the partners themselves. The deed of partnership is a legally binding agreement between the partners who are in business together. It is not necessary to have a deed of partnership in order to set up a partnership, but it is good idea as it will help to avoid misunderstanding and disputes between partners in the future. If the partnership does not have a deed, it will be governed by the terms of Partnership Act 1890. This does not offer solution to many of the problems that can arise and may not suit the way that you and your partners want to work together. Now let us highlight on advantages of partnership over a company. For the creation of partnership, just an agreement between various persons is all what you require. In case of company, a lot of procedural formalities which have to be gone through before company is created. The partners are their own masters for regulating their affairs. The company is subject to a lot of statutory control. Third, for dissolution of partnership, a mere agreement between the partners is enough, but that is not the case of a company, which can be wound up by only after certain set of procedure is followed. Fourth, since all the profits are to be pocketed by the partners in the partnership firm, there is a great incentive for the partners to make business successful, but that is not in case of a company. Fifth, in a partnership, the person who have entered into are individually called partners and collectively a firm. A partnership firm does not have a separate legal personality. A company is a legal entity different from its member. Sixth, a partnership firm means all the partners put together. If all the partners cease to be partners, for example, all of them dies or become insolvent, the partnership firm gets dissolved. A company being a person different from the members may come and go, but the company life is not affected thereby. Seventh, the shareholders of a company can transfer his share to anybody he likes, but a partner cannot substitute another person in his place unless all the partners agree to the same. Similarly, on the death of a member of a company, his legal representatives will step into his shoes for the purpose of the rights in the company. But on the death of a partner, his legal representatives do not get substituted in his place of partnership. 8. The minimum number of members in the partnership is 2 and maximum in case of partnership carrying on banking business is 10, and in case of any other business it is 20. In case of a private company, the minimum number is 2 and the maximum is 50, whereas in the case of a public company, the minimum number should be 7, but there is no limit to the maximum number, and therefore, any number of person can hold shares in a public company. 9th, the liability of the members of a company is limited. but the liability of partners is unlimited. Now we will highlight on the essential features of partnership. As per the definition of partnership, essential features of partnership are listed as two or more people. The Indian Partnership Act 1932 does not prescribe any upper limit on the number of people who can be partners. Minimum 2 people are needed to create a partnership. However, Section 11 of the Company Act 1956 provide that number of partners cannot exceed 10 persons in case of banking business and 20 in other businesses. If the number of partners exceeds the limit, the partnership becomes an illegal association. Similarly, if the number falls below 2, the partnership is deemed dissolved. In nutshell, in banking business, there can be maximum of 10 persons. Any other purpose, there can be maximum of 20 persons. If the number of members in any association exceeds the above stated limit, that must be registered as a company under Companies Act 1956. Otherwise, that will be considered to be an illegal association. The people who are partners in a firm must be competent to contract. If all partners are minors or if there is only one adult partner, it is not a partnership at all. The term person as used in section 4 does not include a firm, Dulcich, etc. versus Commissioner of Income Tax AIR in the year 1956 mentioned in section 354. This is because a firm is not a separate legal entity. As such, two partnership firms may form a partnership out of their separate firms provided their number does not exceed the statutory limit. Business. A partnership agreement must be to run for business. Business includes trade, occupation and profession. Any understanding to run an unlawful business will be illegal, hence no partnership. The word business generally conveys the idea of running business involving numerous transactions. Besides that, a person may become a partner with another in a particular adventure or an undertaking which is successful would result in profit. Sharing of profit. An agreement among partners should provide for sharing of profits and losses. A charitable trust cannot be called as partnership because there is no sharing of profits. Profit sharing is only a prima facie test of partnership, but does not a conclusive proof. The employees of a business may also share profits, but they are not the partners. In particular case, there is no partnership. When a person has lent money to person engaged or about to engage in business and receives a rate of interest varying with a profit. Example, advance money to two merchants who agrees to carry on the business subject to the control of A. In several respects, A was to receive a commission of 20% on all profits. Held there is no partnership. Mallomarch and Company versus the Court of Wards in the year 1872 LR2 CP 419, where a servant or agent is engaged in a business and receives his remuneration as a share of profit. where the widow or child of a deceased partner receives a portion of the profit. Where a person has sold his business along with its goodwill and receives a portion of the profit in consideration of the sale. Although the sharing of profit of a business is a strong test of partnership, yet where the relation of a partnership does or does not exist must depend upon the real intention and conduct of the partners. Unlimited liability. Each and every partner is liable jointly and severally for the obligation of partnership firm. If assets of the business are not sufficient to meet the liabilities of creditor, then private property of partners can be used to meet them. The creditors can claim their dues from anyone or all the partners. If these liabilities are met by one partner, then he is entitled to receive rateable contribution from other partners. Restriction on transfer of shares. No partner can transfer his interest in the firm except to an existing partner to the outsider without the consent of all other partners. He can do so only with the unanimous consent of all other partners. It is based on the principle that the partner, being an agent of the firm, cannot delegate his authority unilaterally to outsider. Utmost good faith. The very basis of partnership business is good faith and mutual trust. Each and every partner should act honestly and fairly in the conduct of business. Limited life. The life of a partnership may be established as a certain number of years by the agreement. If no such agreement is made, the death, inability to carry out specific responsibilities, bankruptcy, or the desire of the partners to withdraw automatically terminates the partnership. Every time a partner withdraws or is added, a new partnership agreement is required if the business will continue to operate as a partnership with proper provisions. The partnership business may continue and the termination or withdrawal of the partnership will be documentation issue that does not impact ongoing operation of the partnership. Mutual agency. In a partnership, the partners are agent for the partnership. Although partners may limit a partner's ability to enter into contract on the company's behalf, this limit only applies if the third party entering into the contract is aware of the limitation. It is the partner's responsibility to notify third parties that a particular partner is limited in his or her ability to enter into contract. The real test is mutual agency. One may say that the true test of partnership is not the sharing of profit by a person or the contribution of capital or the holding of a particular property jointly, but whether the business is carried on by him or by another on his account, so that there is a mutual agency between them. If the relationship of principal and agent exists between the parties constituting a group formed with a view to earn profit of a business, we can say that there is partnership. Law of partnership and extension of the law of agency. The partnership business may be carried on by all partners or any of them acting for all. Thus, the relationship of principal and agent is established among partners, and this relationship is governed by the law of agency. Section 18 provides that partner is the agent of the firm. Cox versus Hickman in the year 1860. a trader carries on his business under the supervision of his creditor. The object of carrying on the business was to pay them off out of the profit of the business. Held, no partnership exists between the traders and creditor. It was rightly absurd in this case. The law as to partnership is undoubtedly a branch of the law of the principal and agent. The liability of one partner for the act of his co-partner is in truth and liability of a principal for the act of his agent. Transfer of ownership. Although it is relatively easy to dissolve a partnership, the transfer of ownership, whether to a new or existing partner, require approval of the remaining partners. Management, structure and operation. In most partnerships, the partners are involved in operating the business. Their regular involvement makes critical decisions easier as formal meetings are not required to get approval before action can be taken. If the partners agree on a change in strategy or structure or approve a purchase of needed equipment, no additional approvals are needed. Valid agreement. The foundation of partnership is an agreement. Section 5 clearly states that partnership is not created by status. The relationship of partnership can arise only out of a contract. Thus, if a Hindu undivided family is carrying on a business, it is not a partnership. Similarly, a Brahmins Buddhist husband and wife carrying business are not partners in such business. The partnership agreement must fulfill all the requirements of a valid contract. There should be free consent, competency of the parties, lawful consideration and object. The agreement to create partnership may be express or implied. The agreement can also be inferred from the conduct of the parties. The agreement need not be in writing except where required under the Income Tax Act or if the partner wish to get the firm registered. Thank you, students.